What conduct in the course of an arbitration is so egregious that it justifies vacating the arbitration award? To find out, you have to read TCR Sports versus Washington Nationals. But it's 18 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, New York Court of Appeals cases in 5 minutes or less. This is the episode on the case of TCR Sports versus Washington Nationals. It can be found at 2023 New York Slip Opinion 02090, published by the New York Court of Appeals on April 25th, 2023. The issue in this case is what facts can be present that would justify vacating an arbitration award under the Federal Arbitration Act. To understand what's going on here and appreciate where this case fits in, you have to understand a little bit about the Federal Arbitration Act, which can be found at 9 United States Code Section 4 and the subsections that follow. That's a federal law that talks about the importance of arbitration clauses and requires courts, when they're adjudicating matters, if a party wants to enforce an arbitration clause, the courts have to respect that. The courts even have to stay proceedings if anyone claims there's an arbitration clause involved. And Section 10 of that Federal Arbitration Act, the FAA, includes the grounds to vacate an arbitration award. Under Section 10A2, it says that among those grounds is where there's evident partiality or corruption of the arbitrators. Okay. This is a very, very fact-heavy case, and I can't possibly get through all those facts and try and keep this close to 5 minutes. But essentially what this is a fight between the Orioles baseball team in Baltimore, Maryland, and the Nationals baseball team in Washington, D.C. For decades, the Orioles were the only Mid-Atlantic baseball team, and a large portion of their fan base was Washington, D.C., because there was no team there. In 2002, Major League Baseball bought the Montreal Expos and moved them to D.C. and renamed them the Washington Nationals. So all of a sudden, there's two teams in the Mid-Atlantic region. To try to accommodate and recompense the Orioles for this loss of fan base and revenue stream, they made a big deal in 2005. And that's the fight we have here in this case. In 2005, there was a deal reached where basically the Orioles and the Nationals would have joint ownership of the Mid-Atlantic sports network, which is like a television network that would have exclusive rights to televise the games of these two teams. And the Orioles would have majority ownership and the Nationals would have minority ownership. So the profits would be split much more to the Orioles than the Nationals. The major expense that the MASN had was the fee, the exclusive telecast right fees that get paid equally to the Nationals and the Orioles. So there's a difference of incentives here. The Nationals have an incentive to make that fee as high as possible, because that's where they're going to get most of their money. The Orioles have an incentive to minimize that fee, because the more they minimize that fee, the more of the profits that MASN has will go to the Orioles. And they have an obligation under the contract here, the agreement, to every 5 years try to negotiate in good faith about that fee amount, how much they're going to pay each of these teams equally. The deal says that if they can't reach an agreement, then they have to go to arbitration, and the arbitration will be by arbitrators that MLB picks, that are part of like a committee, a standing committee that they have to determine the fee. So obviously, the very first time this comes up, there's a fight about the fee, and they're not on the same page, and it goes right to arbitration. And at the arbitration, it breaks down. And ultimately, the important facts to understand in this case that are important to the holding here is that Proskauer Rose, which is a white shoe law firm, represented everybody but the Orioles here. Proskauer Rose represented the Nationals and currently represented each of the arbitrators for teams and MLB. And the Orioles said, that's not fair. This is an objection. I have an objection. Proskauer Rose shouldn't be representing everybody. This is a bias. Also, during the course of these negotiations, Major League Baseball gave the Nationals a $25 million advance to keep them negotiating. Finally, the arbitration panel returns an award, basically much closer to what the Nationals wanted than the Orioles. The Orioles object, send it to court, appeal it, and basically say there was partiality here, evident partiality. The judge in the lower court, the judge in the Supreme Court says, you're right. He sends it back to the same arbitration panel. Orioles said, hey, that's not good. It shouldn't go to the same arbitrators. That's a problem. At that point, the attorney, Proskauer Rose, was out of the case. So that conflict was no longer there. But at that point, Orioles said, hey, we want all evidence of any communication between the Nationals and Major League Baseball. And Major League Baseball and the arbitrator said, no dice. We're not doing that. And then after that, after they basically issued a very similar award, the Orioles again objected, and the trial court basically said, I'm going to send this over for I'm going to send this for an inquest to determine how much prejudgment interest is entitled to go to the Nationals. Okay, very fact heavy. Here's the holding. Here goes to the holding, goes to the Court of Appeals, and here's what they say. They say FAA has to be strictly construed and applied. Arbitration is important. When people agree to an arbitration clause, they're making an agreement about something very valuable, and we have to honor that as a court. So first of all, they find that the conflict existed. That fact that the attorney represented everybody but one of the parties, including the arbitrators and one of the parties to the arbitration, that was an evident partiality. So that is sufficient to vacate the original award. That was right. They say that the advance that the Major League Baseball gave to them, that was not inappropriate. That did not affect anything. They also find that when it came back for the second arbitration, the original defect had been addressed, that there was no authority from the court to change who the arbitrators would be. The arbitration clause under the FAA has to be strictly construed. If they agree that the Major League Baseball Standing Committee will hear the arbitration, then the court has no power to change that. And finally, they say that the Supreme Court was wrong in sending the case for an inquest because that's beyond the scope of the deal. And the arbitration deal and the arbitration clause of that deal didn't allow for the Supreme Court to do that. So the lesson of TCR Sports versus Washington Nationals is you have to apply the contract as written. You have to respect the arbitration clause. And it's a warning for people who enter arbitration clauses. It will be strictly carried out. Be careful what you agree to because that's what the courts are going to give effect to. That's the case of TCR Sports versus Washington Nationals. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.